Hello everyone, my name is Alejandra Munoz and today I'm going to talk about access to information law. The concept of access to information can be traced back to the fundamental principles of democracy and the right to know. The movement for access to government-held information gained momentum in the 20th century, with several countries enacting legislation to ensure transparency and accountability. In Canada, the Federal Access to Information Act was introduced in 1983, establishing the right of access to records held by federal government institutions. This legislation was a response to the growing demand for openness and recognition that citizens have a right to access information about government activities. Following the federal government's lead, provincial and territorial jurisdictions in Canada introduced their own access to information legislation, including British Columbia Freedom of Information and Protection of Privacy Act (FOIPPA) in 1993. Some vocabulary words and terms used in this report are the next ones. Freedom of Information (FOI). The right of individuals to access records held by public bodies subject to certain limitations and exceptions. Privacy protection. The safeguarding of personal information held by public bodies and the establishment of rules for its collection, use, and disclosure. Records. Information in any form, including documents, correspondence, emails, reports, databases, and audiovisual materials. Exemptions. Specific categories of information that might be withheld from disclosure based on exceptions outlined in the legislation, such as personal privacy, national security, law enforcement, or third-party confidential information. Disclosure. The release of requested information to the applicant subject to any applicable exception and exception. Gary Bennett, a lawyer at DLA Piper LLP, Mike Larsen, president at Freedom of Information and Privacy Association (FIPA), Jason Woiwoda, executive director at FIPA, and Daniel Reed, a lawyer at Harper Gray LLP, have shared the valuable insights into the life of lawyers practicing in the access of information field. They highlighted that a lawyer in BC who specializes in access to information typically possesses a combination of legal expertise, knowledge of privacy and information laws, and an understanding of business operations. Some common fields that a lawyer working on access to information may practice include corporate law and government and public sectors, public law and data protection, regulatory compliance, non-profit and advocacy organizations, litigations and dispute resolutions, and legal consultancies. The lawyers also mentioned that the Freedom of Information and Protection of Privacy Act in BC acknowledges people's rights to access their own personal information held by public bodies, while ensuring their privacy is protected, especially in today's world, where personal information is exchanged on a daily basis, particularly with the widespread of electronic devices. However, they also recognize that legislation needs to be revised to keep up with the fast-moving practices in this field, which possess a challenge for practicing lawyers. In an interview that I had with Angelo Muriel, a legal assistant at Vilira Peterson Christie in Victoria, BC, he states that a legal assistant may encounter various common situations like drafting and reviewing access to information requests. He says that legal assistants help clients and organizations with access to information requests. A legal assistant formulates requests, identify relevant records, and ensuring compliance with the law. Another common situation is conducting legal research. As a legal assistant, it is possible that you may be required to conduct a legal research pertaining to access to information laws, regulation, and relevant case laws. This research is of immense importance as it guarantees that all requests and subsequent actions are in compliance with the legal framework, and those are capable of providing effective support for the client organization's arguments or positions. Another situation is coordinating with the government agencies. As legal assistants often work with government agencies and public entities to request information. Legal assistants submit and monitor requests, negotiate charges, and address concerns about availability. Other situation is assisting with document review and disclosure. Legal assistants review documents and prepare reports based on the review records, offering valuable assistance in analyzing relevant responsiveness and potential exceptions. The last common situation is handling appeals and disputes. Legal assistance can be of great assistance to individuals who are denied access or unhappy with decisions made by public agencies. They can help by preparing and submitting appeals or complaints to the relevant oversight organization, such as the Office of Information and Privacy Commissioner. Their services include assistance with completing appeal forms, gathering evidence to support the case, and communicating with the oversight bodies through the appeal process. Documents. Some of the forms commonly encountered in this area include access to information request forms. This form is used to initiate a request for access to information from a public body and has a cost of $10 application fee, not refundable. Indigenous governing entities don't pay the application fee. This request can be made online in the link that appears on the screen. Request business or organization records. To request information about business or organization registered in BC, documents that are filed and registered are public records and are available to citizens for a fee. The type of information that can be requested is business summaries, active or historical registration, certified work, etc. The request can be made online in the link that appears on the screen. Another commonly encountered forms in this field are appeal forms. In case of a denial of access or dissatisfaction with the decision, an appeal form can initiate the appeals process. Consent forms. In some instances, business may require individuals to provide consent for collection, use, or disclosure of their personal information. Confidentiality agreements or non-disclosure agreements. These contracts are commonly used in business transactions, partnerships, or collaborations where sensitive information needs to be shared. They outline the terms and conditions for maintaining the confidentiality of the information and specify the consequences of unauthorized disclosure. Service provider agreement. In situations where business outsources certain services or tasks to a third-party service provider, a service provider agreement is used. This contract outlines the scope of services, performance expectations, data protection obligations, and confidentiality provisions. And privacy policy. A privacy policy is a document that outlines how a business collects, uses, stores, and discloses personal information. And last but not least is record retention and destruction policy. This policy outlines how long business records and documents will be retained and how they will be securely destroyed once they are no longer needed. Contracts. Canada has legislation in place that guarantees access to information, primarily through the Access to Information Act. This act applies to all federal government institutions and provides individuals with the right to request access to records held by these institutions. These are international agreements and initiatives that promote transparency and free flow of information. United Nations Combination Against Corruption, UNCAC. Canada is a signatory to this convention, which aims to prevent and combat corruption globally. It includes provision on public access to information, as transparency is considered an essential tool in preventing corruption. Open Government Partnership, OGP. Canada is a member of the OGP, an international platform that brings together government and civil society organizations to promote transparency, citizen participation, and accountability. The OGP encourages member countries to adopt and implement open government initiatives, including access to information reforms. Organization for Economic Cooperation and Development, OECD. Canada is a member of OECD, an international organization that promotes economic development and cooperation among its member countries. The OECD has guidelines on good governance, including transparency and access to information, which member countries are expected to adhere to. North America Free Trade Agreement, NAFTA, and United States-Mexico-Canada Agreement, USMCA. While these agreements primarily focus on trade and investment, they include provisions related to the transparency, access to information, ensuring that each country has mechanisms in place that provide access to information regarding their respective trade policies. Resources for a legal assistant. As a legal office assistant working in the field associated with access to information in business law, there are several resources available for public access that may assist you in navigating most aspects of this field. One is Freedom of Information and Protection of Privacy Act, FOIPPA. This is the provincial legislation in British Columbia that governs access to information and protection of privacy, providing a framework for individuals to access records held by public bodies while also protecting the privacy of personal information. Another good source is the BC Freedom of Information Act and Privacy Association, FIPA. This is a non-profit organization based in British Columbia dedicated to promoting and defending freedom of information, privacy rights, and government transparency. One relevant leading case in this field is West Coast Environmental Law Association versus British Columbia Ministry of Environment. In this case, the issue was whether records pertaining to the government's interaction with a private corporation in the context of environmental assessment were subject to disclosure under the BC's Freedom of Information and Protection of Privacy Act. The West Coast Environmental Law Association had sought access to records held by the Ministry of Environment concerning the environmental assessment process for proposed liquefied natural gas. However, the ministry refused to disclose certain records, citing exceptions under the Act. The court examined the application of the Act and the exceptions claimed by the ministry, and it found that some records were subject to disclosure, while others were exempt from disclosure based on these specific exceptions. This case underscored the delicate balance between transparency and the protection of certain interests in access to information requests. Thank you for your attention, and I hope you find this presentation enjoyable.